To the case of People versus Robert Durst. Mr. Durst is present. Mr. Lewis is at his side. And on WebEx, I see Mr. Chesnoff, Mr. DeGuerin, Mr. Ray. We're assisted by Lois Haney. And I see Mr. Lewin, Mr. Balian.
Mr. Henderson.
Mr. Henderson is over there in the corner, representing the people. All right. We have a few orders of business today, and welcome to Inglewood, Apartment 1, our new home. I wanted to first disclose my communication with the jurors on March 30. This is from our jury commissioner, read this script to all jurors. The trial of People versus Robert Durst will reconvene on Monday, May 17, 2021. You are ordered to appear at the Inglewood Courthouse, Department 1 on that date at 9 a.m. We will contact you soon with directions and parking information. The court is taking several additional steps to protect your health and safety. Masks and social distancing are required. Persons experiencing COVID-19 symptoms may not enter the courthouse. Our new spacious courtroom is limited to 1/3 occupancy and has been retrofitted with MERV 13 ventilation with at least 10 air changes per hour. There is regular deep cleaning of the courtroom and hand sanitizer will be available. We encourage you to make a vaccination appointment as soon as it is available on myturn.ca.gov. Do not read, listen to, or watch any news report or commentary about the case from any source. Do not talk about the case or about any of the people or any subject involved in it with anyone, including the other jurors. Thank you for your patience. We look forward to seeing you on May 17th. All right, first order of business I have is a mistrial motion, which is essentially a restatement of a previous mistrial motion with additional factual claims added, but the same concept that we've previously seen. The people did not respond in writing, and is there anything else from the defense on this?
Yes, Your Honor. It's David Chesnoff on behalf of Mr. Durst. First, I'd ask, Your Honor, that you incorporate all prior briefing and arguments that have been made as part of today's record. Will the court be kind enough to do that?
Yes.
Thank you. I'm going to just briefly state the following, Your Honor. An unprecedented event, a global pandemic, caused Your Honor to adjourn this trial over 1 year ago. This event disrupted the world and without any doubt impacted the lives of our jurors in a way that none of us could have imagined when conducting voir dire or selecting them. As this court is aware, courts have historically declared mistrials for far shorter adjournments than we have, and we've argued that previously. We once again implore this court to mistry the case and let us choose a new jury, a jury that has not had 1 year to have outside influences as affected, whether they be from the pandemic, their economic situation, their jobs, their family, or whether it's media or social media accounts regarding Mr. Durst, of which there have been several in the time period that we have been out of court. And we ask you to understand that you're now asking these jurors to put aside all the influences that have occurred since they were selected for this jury and come back in and provide Mr. Durst with a fair and impartial jury, and with no intent to disparage these people. It is blindness to human and social reality to assume that a year off they have not been impacted by the matters that I have mentioned. Your Honor, as we previously stated, we respectfully believe that People v. Gray is distinguishable. First, in Gray, it was his choice to pursue the appeal process with the knowledge that doing so would result in delay. Second, a death penalty trial is divided into two discrete phases, after each of which the jurors are called upon to render separate verdicts, decreasing the risk of prejudice from an interruption such as we've had. Your Honor, I appreciate that the court has given us lots of time to discuss this and lots of briefing, but we just simply say to the court that a pandemic not of Mr. Durst's making has led to a dramatic delay and adjournment in this case through no fault of his or anyone other than an act of God. And as a result, this court should not allow a case that has been adjourned for a year to proceed with the same jury. And we would ask for a mistrial, Your Honor.
Thank you. People submit?
Submitted.
Thank you. The record should also reflect that Mr. Durst is using the services of our certified court reporter for the hearing impaired, and he's able to follow everything on the screen transcript. But I have the same thing here for myself from our court report, real-time report. As for the motion, I'll note first of all that we can proceed safely. We are monitoring all of the health data. There has been a marked improvement in every measurable area to the point where trials are beginning to resume in Los Angeles County. Our court has worked with the County Department of Public Health to assure health and safety. I'll note that the secondary sources and footnotes in this brief are not persuasive evidence to the contrary. Secondly, as to the issue of whether a fair trial can be had, to quote People versus Ayala, 23rd Cal 4th 225, to use the terms of art, the chances of a fair trial are not irreparably damaged. Let's look at People versus Gray, 37 Cal 4th 168. It's a capital trial, but capital trials are unitary trials. They're bifurcated, but they are unitary. The evidence from the guilt phase is vital for determination of the penalty phase. There is a distinction, but that distinction is without a difference. When you read People versus Gray, that dispatches all concerns noted by the defense in their brief. What the cases upholding the longer adjournments share is good cause for the adjournment. Good cause is the key factor. The second important issue is whether adequate precautions are taken. People versus Gray notes that in that instance, the jury was admonished 5 times during the break. When we admonish the jury again before our trial commences, that will be the 10th admonition to that juror with language that should assure their continued fairness. I'll note further that as far as the point about the few witnesses who did testify before the adjournment, there is no prejudice to the defendant if the jurors forgot the incriminating evidence that the people presented. But if I'm not understanding that evidence, or it's possible import for the defense is free to recall those witnesses, or the jury can ask for a readback if they don't recall particulars, or if there's a difference of opinion at the time of argument what those facts were. I certainly will encourage and allow those jurors to have a readback of that couple of days of testimony, a small portion of the trial relative to the balance. So for all these reasons, this motion for mistrial is denied.
Your Honor, can we just add, I think the court's aware of this, but I just want to make sure that those witnesses were all audio recorded as well. So in terms of any prejudice, were their requests to have that those witnesses recalled, etc., they could have their testimony played in the same emotion, state, etc., that it was given. So we have better than just a naked transcript. I just wanted to make sure.
Now, yes?
One thing, Your Honor, what seems to be a point of transition, I have been informed by a couple of folks that the audio feed of the proceedings is not making it to the public.
It's not what?
Making it to the public.
Okay.
They can see us, yes, but they can't hear us.
Let me speak with RJA about that. This is the radio blast.
Some people would consider that good news.
I'm just informing the court.
No, so, of course, we're talking about witnesses, not about motions, but still, we have an open court, we have a number of seats that are available. There are a number of members of the media, and there are other individuals in our audience who can report that. So our trial is public today. We hoped also, and allowed radio blast, in addition to the WebEx that counsel are appearing, except for Mr. Lewis, the other defense counsel are on that. Anyway, thank you, and Robin will look into that to make sure that our
Yes, Your Honor.
public broadcast is going forward. So I do want to suggest to the people that the people order transparent masks, not shields, but masks, and the defense also, if you're calling witnesses. Masks are required in the courtroom, and I did a little shopping. I found 20. So I've done this calculation. There are 24 minimum participants, 24 minimum. 5 court staff, that's judge, court reporter, cart reporter, bailiff, clerk, 5. Defendant is fixed, 1. Jurors, minimum, fixed, 12, minimum. Public is fixed by court policy, 1 press, Penal Code Section 1095 in a special circumstances murder case, 2 prosecutors, 2 defenders. That's the minimum, 24. Primary variable, 10 alternates. Right now, we have 10 alternates, and they have the highest priority for seats. We will certainly not excuse an alternate without a good cause, leaving us with 6 free seats guaranteed. Additional seats as alternates are excused. I will assign 2 to the court, 1 for the media officer and 1 for a second bailiff. The Sheriff's Department has requested a second bailiff. Prosecution, 2 seats. That I expect the 2 lawyers of record, the 2 additional lawyers. So your 4, I'm sorry, you have 5 lawyers, right? 2 more lawyers of record. Defense, 2. I expect that's 2 additional lawyers of record. Then, with a reduction in alternates, priority seating will be as follows. 1, prosecutor of record. 2, defense consultant or supporting attorney. 3rd seat, prosecutor's IO. 4th seat, defense consultant or defense supporting attorney. 5th seat, prosecutor's second IO. 6, defense designee. The prosecutors or the defense may trade any space for a lawyer. In other words, if you need an IO to be here, unless we have the free seats, okay, they can trade out. Defense can trade out a seat. Court seats will trade out. We may have a JA trainee at some point, or I'll give it to additional media. All right, so that you should be able to. I don't know how many alternates we will lose. I hope for fewer, but as a practical matter, I'm sure we'll lose a couple. So there should be more. There should be enough seats in that fashion. That's just how we're going to proceed.
Your Honor, if the court ends up changing and the court's aware, the CDC has made some comments about the 6 feet rule, et cetera. There have been discussions in the media and in the scientific journals regarding is that necessary, et cetera. If the court ended up changing, let's say, to 3 feet, I assume that would change the court's calculation.
Well, not that alone would not, and this is the reason why. Because there are 2 concerns. One is the distance from other seats. The second is capacity. In other words, we are limiting this room because of constraints of ventilation and the size of the room, we're limiting capacity to 1/3. That may change also. It's likely to change in California. When it changes port-wide, I would change that also.
Okay, understood. Your Honor,
Yeah.
just if the court hears about it, will the court let us know by email if, for instance, between now and May 17th, because there are a lot of changes going on, things are getting better, if that restriction changes, will the court let us know?
Yes.
Thank you.
All right, let's talk about 1101B. The defense made a second mistrial motion premised on 1101B. You know that the tentative is a denial as to the defense motion, but if you wish to add.
Yes, thank you, Your Honor, in order to make the record for Mr. Durst. Your Honor, our jury has been presented a theory by the prosecution that the Morris Black case, which was an acquittal, and Mrs. Durst's disappearance, which is a never charged crime, is evidence to be considered by our jury to find Robert Durst guilty of the homicide of Susan Berman. This is in a case where the prosecutor has repeatedly acknowledged, and this court has affirmed, is a circumstantial case, absent any real forensic evidence from the scene of the charged homicide. This will violate due process, Your Honor. In Kipp v. Davis, after we commenced the trial in this case, the Ninth Circuit opined that the use of alleged prior bad acts without sufficient similarity or to be so unusual as to be a signature is a clear due process violation. Absent this high level of unusual commonality, admission of alleged prior bad acts creates a high risk that a juror will believe that if Mr. Durst illegally killed Black in spite of the acquittal, which shows how prejudicial this graphic evidence of dismemberment could be, and was responsible for Mrs. Durst's disappearance, he had the propensity to kill Susan Berman. Add graphic photos, hundreds of them, and the domestic violence evidence already admitted, and now the late argument for Douglas Durst evidence to come in, we will have a far more egregious due process violation than found in Kipp. The people seek to use an acquittal and a never charged crime to inflame the jury to bootstrap their admitted circumstantial case. The court is also using purported similarity of disposing of the body in Galveston and New York for its rulings. The problem is, if we were on trial for either of those cases, that could be an argument. But disappearance is in no way a similar method in Berman. It is dissimilar. As Kipp stated, the admission of other crime evidence violates due process where, and there are 4 factors. The balance of the prosecution case for Susan Berman's murder is circumstantial. That's the case here. The other crime evidence was similar to the crime for which the defendant was on trial. Mr. Lewin describes Galveston and Mrs. Durst as homicides. Number 3, the prosecutor relied on the other crimes evidence at several points during the trial. Well, in this case, it was a part of the opening. It's going to be part of the presentation of the case. It's going to be part of the closing. If we put on a case, it will be part of the rebuttal. A defendant's right to due process is violated when a court admits other crimes evidence where there is no permissible inference that could be drawn from the evidence other than conduct in conformity with the charge offense. Kipp relied on Garceau and explained that presenting evidence of a case like the Frizzle crime, and that was one of the homicides in the Kipp case, where there is no conviction, both Black and Mrs. Durst are no convictions, just like the court pointed out in Kipp, Frizzle was no conviction. Or worse than Garceau, where at least the defendant had been convicted of murder several months before his second murder trial, and Garceau was ruled to be no good as far as due process. And we know that Mr. DeGuerin and Mr. Lewis had an acquittal for Mr. Durst in Galveston. Judge, there's no highly distinctive pattern suggesting intent, but rather what they're trying to do creates for the jury an opportunity to convict based on propensity. Your Honor, I don't know if Mr. Lewis had an opportunity to talk to you, but if there's a method that I can add something at sidebar, which I feel is more appropriate at sidebar with respect to that argument, I would like to. You tell me after I finish, please, how I could accomplish that. There is no signature here, Your Honor, of a criminal. It is a circumstantial case. It has been stressed in the opening. It will be stressed in weeks of DA evidence and provocative, inflammatory photographs. It's highly emotional. These are all the things that Kipp talked about. The dismemberment is emotional. The DV material was highly emotional. DV evidence is always emotional. People are struck by it. Even the disappearance of a promising medical student is an emotionally charged argument. When I read Kipp, Your Honor, I don't know how to say this. When I read Kipp, Your Honor, I immediately recognized that the state's prosecution of 3 separate alleged murders, as the people have called them, as evidence of one, was the very due process violation the Ninth Circuit Court of Appeals opined that the California Supreme Court and lower courts missed. And I ask you, Your Honor, please avoid this due process miscarriage here. There is no clearer case of a lack of signature, a lack of commonality, more emotionally charged evidence being used to charge somebody with the same crime that they're on trial for than this one. We've always taken the position, Your Honor, that Galveston, even on just a kind of a 404B argument, was more prejudicial than probative. But we're asking you, you have to exclude Galveston, Your Honor, and to do that, he can't unring the bell of what he did in his opening, and that's why we asked for the mistrial. I'm imploring you, Your Honor. I know you gave a tentative, but I really am pressing you, Your Honor, to recognize that you should require Mr. Lewin to put on his circumstantial case free of this prejudicial information. Your Honor, the defense even recognizes if he wants to talk about the fact that there's a case that Susan Berman may have been a witness in, we understand that. But to go into all the graphic details about the relationship between Mr. Durst and Mrs. Durst, and then compound that with a presentation of dead body parts. That's what the case they're doing, Your Honor. They're showing the jury dead body parts. And when I speak to you at sidebar, I will tell you why I think that will ring true to you, Your Honor. And I appreciate, as always, the opportunity to be heard.
Thank you, Mr. Chesnoff. Now,
If
Mr.
it's
Lewis.
easier logistically, I could supplement the record regarding the material that Mr. Chesnoff wants to. It will only take a couple of minutes, but I agree with Mr. Chesnoff to make his presentation fulsome. We should include this tidbit.
So,
I have no problem, Mr. Lewis, approaching the fence with Mr. Lewin and informing the court, with the court reporter, of what my point was, that I didn't want to do an open court.
well, all right. I know that I received something under seal that was at some point that was.
This is totally separate, Your Honor. This has to do with an observation that the court relayed to us previously, and I'd just like Mr. Lewis to share it with you, with the court reporter, so it's part of our record for mistrial.
Let's go into. Why don't we go into the jury room? There's enough room for four people, including the court reporter.
Thank you, Chip.
Yes, Your Honor.
Lewis.
Yeah. So the jury room's over here on this side, and.
You will be on mute until the court comes back in session, okay?
Thank you.
You're muted.
I am going to incorporate by reference the People's 1101 brief filed on December 27th, 2018 into my own ruling, but because it explains explains in a great detail bases that I will elaborate upon. I did not expect argument.
Because I don't think it's fair to Mr. Durst that we were required to respond when the people already have taken the position that they didn't need to respond.
The rules in California are very clear. I may make any argument that does not cite any cases which have not been previously presented. So I will comply with my rules under California law, and I will respond as follows. First of all, this is really...
Your Honor, could you make a ruling on my request, please?
Yes, I agree with Mr. Wood. Please proceed.
So, again, this is just another 1101B opposition. Originally, the motion talked about Galveston, and then defense counsel brought in the Kathy Durst situation. And again, if this were granted, this is really just another motion for a mistrial. But I think it's important to look at, first of all, the record. And I'll start with the purpose of this motion supposedly was because of the case of Kipp versus Davis. And a few observations on Kipp versus Davis I think are important. Number one, this is a 1987 Orange County death penalty case where the trial court allowed admission of an uncharged rape murder in Long Beach. There was a rape murder also in Orange County. There was no evidence in the record in that case of the kind of extensive analysis that this court conducted in this case. We've had motion after motion, hearing after hearing, and the court went through and gave detailed explanations, which I will cover in a moment. In addition, what is also interesting is Kipp versus Davis does not stand for any new legal principle whatsoever. It is merely two appellate judges who felt that there had been an abuse of discretion. It's interesting.
But most specifically, it's in the interpretation of the facts. So
Correct.
There's an abuse of discretion in the interpretation
Of the facts.
So
And Judge Wynn, the third justice, actually had the much more compelling argument that in fact that's exactly what was going on, that the court wasn't giving proper deference to the prior factual findings made by an appellate court and the California Supreme Court. So let's go through and let's take a look. First of all, the argument that was made in Kipp was an argument that was rejected by both the Court of Appeal and by the California Supreme Court because it was a death penalty case. And that argument was rejected. It is not binding. It is not controlling authority. It is a federal case that the court, if the court wanted, could view as persuasive. Now, there is no comparison when you look at the relevance and connection in the 1101B evidence in that case with what we have in this case. And I think it's important to briefly explain what the history is. You want me to slow down? Certainly. March 2018, the defense filed their first motion in opposition to the Galveston 1101B evidence. And I'm going to separate for a moment. The Kathy Durst evidence is necessary and admissible to support the special circumstance. So that is a completely different argument. We have to prove, in essence, that Susan Berman was killed because she was a witness to a killing of Kathy Durst. So in essence, we have to prove that Mr. Durst killed Kathy Durst. And a part of that evidence is certainly, in what's relevant in California, is the 1101B evidence. I should note that the defense, as far as I know, never even filed a motion, never filed anything written regarding this issue, period. Now,
They did. This was you responded in December of 2018.
No.
That was your reply.
No, I'm talking about the Kathy Durst that was divided up.
1101?
They never filed a motion on the Kathy Durst because it's separate. We had an 1101B domestic violence, and we had 1101B Galveston. So as of this time, they still have never filed a motion. It wouldn't matter because in the end, it's absolutely relevant. It's absolutely probative, and it's actually necessary to, again, support what we have to put in terms of proving up the special circumstance. So December 27, 2018, we filed our motion regarding the admissibility. And the defense in their motion, Your Honor, if the court remembers, their motion focused first on collateral estoppel. That was the first argument as to why the Galveston evidence was not admissible. That was rejected because the case law is very clear. Collateral estoppel doesn't apply. Then, briefly in that motion, they addressed 1101B. When we filed then, they filed a reply January 8, 2019. We filed a surreply January 11, 2019. And on January 15, 2019, the court conducted what can only be described lengthy and complete, does not give the respect that hearing actually calls for. I mean, the court went into detailed explanation, and the court, of course, dismissed right out of the top. The court said, quote, collateral estoppel is out the window, it's not the issue. And then the court did an extensive level 1B analysis under several theories. And I'm not going to go through each of the theories in terms of explaining why the court said it, but the court admitted the evidence: 1, consciousness of guilt; 2, common plan; 3, modus operandi regarding the execution style killing of Morris Black; 4, knowledge; 5, modus operandi regarding dismembering and disposing of body parts as it related to Morris Black, and the inference that the same had happened to Kathy Durst; and finally, witness credibility pursuant to Evidence Code Section 780 as to a witness's fear of Mr. Durst based on the information that they had and how that affected their reporting or testifying. The court, again, detailed explanations. The defense has said that this is a purely circumstantial case. It is not. We have a confession of Nick Chavin. We have what we will call a very borderline confession when he was interviewed by law enforcement. So when you start saying that it's purely circumstantial, that's wrong. But in the end, there's no different standard under 11(1)B for circumstantial versus direct evidence cases. So defendant has made this motion, Your Honor, for reconsideration as recently, if you recall, on March 20th, after we had done opening statements. They moved yet again for a mistrial, saying that that in essence they were being prejudiced. So in the end, there's no new information here. Kipp is not controlling. Even if it were, the difference in the analysis that the court did is not comparable in that case. The evidence is admissible for all the reasons the court said. This is not a closed case, and I'm certain that this will not be the last time that this motion is brought forth, because by my count, this is at least the 4th time that they've relitigated the same motion with no new information. Kipp is simply inapplicable. Submitted.
You may reply to any part of that you hadn't already addressed, Mr. Chesnoff.
First of all, Your Honor, the record should be clear. We ask for mistrials when we think they're appropriate in order to render effective assistance of counsel to Mr. Durst. We don't take it lightly. Every time we've done it, we felt we were righteous in our motions. We were proven right about the need for a mistrial due to COVID when it was first raised, and we were told that it was almost Trumpian, that it was going to go away quickly. So this constant reference to the fact that we make motions for mistrial as if we're doing that for some reason other than to protect Mr. Durst's rights to a fair trial is actually tiring, Your Honor. Secondly, Your Honor, if you apply a factual analysis to the facts of the evidence which the state wishes to introduce with regard to Galveston, with regard to Mrs. Durst's disappearance, to prove the murder of Susan Berman, you do not find the kind of signature or conformity that Kipp talks about, and Kipp reviewed the record de novo, Your Honor. It was not just dealing strictly with the issue of abuse of discretion. They went through the facts as detailed as they could and reached a conclusion that the previously unconvicted case involving Frizzle's homicide had no place in the Howard prosecution. And it just strikes me that you can't glean facts from Galveston, where he dismembered a body and tried to make it disappear, to a situation in California where Miss Berman is found in the same position that she was when she passed, and Mr. Durst, not trying to hide evidence, wrote a note in which he says, "You'll find the body." So the parallels that Mr. Lewin tries to draw, that somehow this is a pattern that he operates in, there's no similarities between what happened in Galveston and what happened with Miss Berman. We will agree, Your Honor, that the fact that Mrs. Durst is missing can be raised by the prosecution as a reason why police may Berman, which we know never occurred, and which the court has pointed out on several occasions. But to suggest that the graphic dismemberment photos from Galveston in any way are connected to the homicide that Mr. Durst is on trial for, it most respectfully, Your Honor, borders on absurd. They're totally different. And he was acquitted. So when Mr. Lewin says that we do this over and over again, one of the reasons we do it over and over again, Your Honor, is the defense team continues to be baffled why Mr. Lewin thinks he has to show dismembered photos. I think it's up to 200 now or something, last time I saw. Why he has to continue to inflame this jury with the Galveston case, which has no connection whatsoever with Miss Berman's position as a potential witness in Kathy Durst's disappearance. Nothing. There's not one connection between Miss Berman and Galveston. And that's why we keep doing it, Your Honor. And I appreciate the chance to respond. I would have liked to have been able to have a written response, but I understand, you know, once again, being educated on California law, so Mr. Lewin wants to reply like he did, that's fine. But he doesn't really reply, Your Honor. All he does is say, we've raised it before, and the court's reasoned the way it has. But I'm asking you, Your Honor, to rethink the reasoning, especially as it applies to Galveston, because I am befuddled at how somehow that crime, if it was a crime, or the acquittal, which it was, somehow shows a signature that provides the jury with evidence that supports a conviction beyond a reasonable doubt in the California murder of Susan Berman, other than just to show that Mr. Durst commits murders, which is what Mr. Lewin has been doing from the beginning. He called him a murderer there, even though he was acquitted. He's called him a murderer in New York, even though he's never been charged and a body's never been found. So he just gets to say it, and that's enough of a connection. That most respectfully, Your Honor, that is not the kind of connection that meets constitutional muster. It is why it's going to be a due process violation, and most respectfully, Your Honor, we will continue to raise this, because we are there to protect Mr. Durst's right to a fair trial, regardless of what anybody's opinion of Mr. Durst is. We have a jury that's supposed to decide whether he's responsible for Ms. Berman's homicide. That's what they're there to do. They're not there to judge whether he killed Boris Black or he's responsible for Kathy Durst. Let the New York police and DAs prosecute him. They already won once, so they can't do anything in Texas. Let's get on with the Susan Berman murder. Thank you, Your Honor.
Thank you, Mr. Chesnoff. The defense invited me to reconsider my reasoning, and I have read the cases again. I have read all the briefs again, just to be sure, because of course, Mr. Chesnoff, I have great respect for your colleagues' legal acumen and your vigorous representation. I hear you. It's an important issue worthy of my reconsideration. So this motion for a mistrial is based on Kipp versus Davis, 971 F. 3rd 939. It was decided last August after we adjourned. So that's why it's being brought to our attention now. Kipp reversed the federal district court's denial of a habeas corpus petition, where the state court's factual determination was unreasonable. Not an abuse of discretion, because we're not looking at a trial judge's discretion. Rather, it is the finding of fact by the California Supreme Court, or their interpretation of facts, and that is viewed through the lens of the federal habeas corpus law, the Anti-Terrorism and Effective Death Penalty Act. Kipp held that there was not a, quote, highly distinctive pattern, unquote, such that the similarity of the two crimes could tend to prove Mr. Kipp perpetrated both murders. Kipp does not question California's law of character evidence. The issue is whether the state court unreasonably interpreted the facts, and because it did, in this case, misstating aspects of the condition of bodies, because it did, whether that violated due process. The standards that Mr. Chesnoff describes sound like, but are not standards for admissibility of evidence. They're standards for evaluating a due process claim of this nature. So that's what those words indicate. So using the standard that Mr. Chesnoff described for admission of evidence of very similar offenses, which could be prejudicial to a jury were they not otherwise admissible because of their similarity. The offenses were similar, though the facts justifying their admission, the particulars about the bodies were not in fact similar. So the California Supreme Court's ruling violated due process given the unique circumstances of that case. In that case, there was not substantial similarity between charged and uncharged murders. Thus, it could not be used to prove Mr. Kipp's identity. In our case, the evidence of Morris Black's killing is not admitted to prove his identity as Ms. Berman's killer. Rather, it's admitted to show that both killings are part of a larger plan or scheme to eliminate witnesses. And that's the fundamental misconception of the defense motion, that like the evidence in Kipp, this evidence goes to identity. The ultimate fact this evidence tends to prove is not the identity of Susan Berman's killer, rather it is the special circumstance that she was killed because she was a witness. That is a different sort of ultimate fact. It's the people's burden of proof of the special circumstances allegation that the murder of Susan Berman was committed because she was a witness. Similarity of killings is not required. Similarity does arise in two instances in my previous 1101B ruling. First, the people argue that Morris Black and Susan Berman both were killed by gunshot wounds to the back of the head in their own homes. I did not accept that as a basis for admitting evidence of the Morris Black killing, and it's with that's the exception, the only exception to my otherwise accepting the people's 1101B brief, which I am incorporating by reference. It's 12/27/2018. Brief. The only instance in which I considered similarity to prove identity was in allowing the people to show that Mr. Durst did dispose of Mr. Black's body, was rationally also could show that he disposed of Kathy Durst's body, particularly when other evidence points to this fact, and that would tend to prove that she was killed and that he killed her, and rebut the argument that she disappeared of her own volition. So this evidence of identity goes to the special circumstance and not the charged murder. But if that isn't enough, the identical evidence is also admissible, regardless of its similarity, to prove the common plan and scheme of eliminating evidence and witnesses, which tends to prove the special circumstance of witness killing and Mr. Durst's motive to commit the charged murder of Susan Berman. There were actually 5 theories of admissibility in the brief. There were 6 theories. I accepted 5 of the theories, including Evidence Code 780, which affects the credibility of witnesses and their fear of coming forward, their fear of testifying because of the grisly details of this murder and body disposal. So the evidence is material, it's probative in multiple ways, and I've already ruled it should not be excluded under Evidence Code 352, and that's not addressed by Kipp. Now, in their brief, the defense argues competing inferences and facts in refutation, highlighting the court's own observations regarding particular facts. It is the similarities, however, rather than the differences, which determine admissibility. That's People versus Kraft, 23 Cal 4th, 978, 1061. The defense is free to argue the contrary facts and the contrary inferences of these facts at the trial to the jury. It's for the jury to consider this evidence, and they must not accept it or consider it unless it's proved by a preponderance. That's People versus Carpenter, 15 Cal 4th, 312, 382, and Huddleston versus U.S., 45 U.S. 681, 689, which recognize the other crimes evidence could be considered and need be proved only by that standard. So if it isn't probative, then ask the jury to disregard it. So the case, it's true. It's true that this is a gory stuff, but it is relevant to prove multiple points in this case. It takes on different meaning when viewed considering the other homicides. It's different meaning from its meaning in the trial, where Mr. Durst was acquitted because there was a reasonable doubt at that time and place about that killing, but in our context, he's not in jeopardy for that. But the facts of that case look very, very different when considered in light of Mrs. Berman's murder and considered in its relationship to Kathy Durst's homicide. So Kipp is not like this case for reasons I've explained. Kipp is limited to its facts. Kipp does not change California law. There's nothing new, and the motion is denied.
Your Honor, may I ask the court a question, please? If we are in the middle of this trial and there is no proof beyond a reasonable doubt that Morris Black was a witness to anything, will the court reconsider our mistrial motion? Because we're all baffled at this concept that somehow there's been a finding that Morris Black was a witness. That's a theory that I guess Mr. Lewin wishes for, but based on my colleagues from Texas' memory of the trial and their reading of the transcripts, I don't understand where the court is making a finding that he's a witness. It's like in the cases that compare evidence, they know there was a rape because they have a rape kit. They know there was a murder because they're dead. They know that the person was picked up at a bar because they have surveillance of them being picked up at a bar. But we are baffled at the thought that somehow Mr. Black was a witness against Mr. Durst on what subject?
All right.
And that is pure conjecture. That shouldn't be the basis, most respectfully, Your Honor, for a finding that somehow that shows the same connection to Susan Berman potentially being a witness.
So, yes?
I'm just, I don't know how to say this other than saying it's taken from pure cloth, Your Honor. Really, I don't understand it. I don't think anybody on our side of the table understands it.
Let me be clear then, because I heard the arguments, I read the briefs of both sides, and no, it's not proof beyond a reasonable doubt. Here it's proof to a preponderance of the evidence before the jury may consider it. And I will add that as far as circumstantial evidence goes, any fact upon which a finding necessary to a finding of guilt, any fact upon which that proof depends must also be proved beyond a reasonable doubt. So I will give you that. And if evidence is not presented that I'm going to describe now to support this theory, sure, I'll consider your motion, but I am told that there's an offer of proof of evidence, and that's what I use to determine if there is a rational relationship, a reason to believe that evidence would tend to prove something, that this evidence could be probative of a material fact, either an ultimate fact that is an element of the offense or a defense, or an intermediate fact. Those are facts from which an ultimate fact can be inferred. So here, I am told that the people will present evidence that Morris Black came to learn that Mr. Durst was impersonating, that he was in fact Mr. Durst, that he's living in this building under an alias, concealing his identity, right? And so that's part of the proof of a people's case, right? This is it's not the most important witness. It can be any witness. So this could lead to Mr. Durst's apprehension. It could prove his identity. It could prove his flight. It could prove that he's concealing evidence, concealing himself. This is all.
That's all, Your Honor. Most respectfully, that's fine. But then why do you have to show the pictures of the dismembered bodies?
Now the dismembered bodies. That's a different question. The dismembered bodies shows destruction of the body, right? So the body is missing. People might say Morris Black is missing. He is not dead, which is a sort of a parallel to the special circumstance. The people are showing that there is a crime was committed, or at least he believed he would be prosecuted. I think more properly, believed he would be prosecuted for a crime. And
so then, Your Honor, assuming that the court, I know what the court's ruling is. So now I'm asking the court to restrict the people to a presentation that Mr. Durst removed the body without having to show them the chopped up body.
right, but I mean the chopped up body is, as much as it's prejudicial, it also is I mean, a pretty vivid picture for witnesses. In other words, these are witnesses who...
That's the whole, but most respectfully, Your Honor, that's the whole point, but it's not necessary for a logical extension of the argument that you've just made as to why it should come in. All it does is inflame. It's not there to show disappearance, it's there to inflame. They can show that he moved the body.
Okay, now we did...
Without showing a chopped up gizzard.
May I say something here?
Yes, Mr. Bailey wishes to reply, and I'll let him reply to this part.
Your Honor,
Thank you, Your Honor. Thanks.
the lengths that Mr. Durst went through to hide Morris Black's body are extraordinary, and that shows how serious he was about hiding this evidence and what he would do to avoid apprehension from New York or LA authorities at that time. I mean, it's an extraordinary act, and it's extremely probative to show the lengths he would go through to not get caught, which would help explain what he would do to not get caught when Susan was going to speak with authorities.
The other issue, Your
Susan
Honor,
was what?
the other issue, I think the most
What did you say? What Susan was what?
When Susan was going to speak with authorities, or so he thought, based on his own words.
The other issue, and I think what's even more important than what the court originally based its ruling on, is that the people's position on this and the common plan and scheme argument goes back to everything started with Kathy. There is compelling circumstantial evidence, as the court is aware, from the dig note, from the phone calls, from the statements that he's made, that Mr. Durst killed Kathy and that he got rid of the body. These are statements that are also supported on the forfeiture by wrongdoing statements with respect to Susan Berman. Now, when you add that up and you look at the fact that we need to show everything started with Kathy, and these other two murders are just a result and a part of that common plan or scheme to cover up for the first murder. There is circumstantial evidence, there's direct evidence, first of all, that Mr. Durst was aware that Morris Black knew who he was. There is direct evidence that they were going to the library every day. There is direct evidence that there were shows going on at the time before Mr. Durst was murdered, before Mr. Black was killed, where Mr. Durst was identified as a suspect in his wife's disappearance. Mr. Durst has said, both to myself and to the filmmakers, that Morris Black, and I'm paraphrasing, he had never hidden from the police like I had, but yeah, he had tried to start over as well. So when you add it all up, and then, Your Honor, it's amazing, the defense is arguing that Mr. Durst is being prejudiced by the fact that he dismembered a body. There's no argument that Mr. Durst dismembered a body. Mr. Durst has admitted that's what he did. So it's a little bit disingenuous to say, listen, my client dismembered a body for the purpose of getting rid of it. And there's a no-body case which he is being, which is a part of the special circumstance and a part of the people's proof. It is unfair to use my client's admission that he dismembered a body because it's going to connect him up to Kathy Durst's disappearance, which they believe is irrelevant. It's relevant for all the reasons we've said. And the last thing I'll say is, where are these 200 photographs that we have shown? In our opening statement, we did not have a bunch of photographs. It is important, by the way, and there's going to be testimony, and Mr. Durst talks about it, the way that Morris Black was dismembered. There is a strong circumstantial argument that that is not the first time that Mr. Durst has done this kind of conduct. It is demonstrated by the way that he was cut up. It is demonstrated by Mr. Durst's response in discussing the dismemberment. So for all those reasons, Your Honor, and you made an impeccable record previously, the defense is simply, here we are, and by the way, they themselves wanted to question during jury selection. They wanted to question about the dismemberment. They wanted to question about Kathy Durst. I understand their problem. I understand their issue. Their client, the evidence is going to demonstrate, has killed 3 people. And they don't like the fact that the jury is going to hear the whole story. Well, unfortunately, that's not something they control, the court controls, or we control. Mr. Durst committed these acts, and either the jury is going to decide by preponderance that in fact these other acts are related beyond a reasonable doubt with respect to the special circumstance of witness killing, or they're not. So we hope this is the last time that we litigate this. I mean, it's almost every time the issue comes up, the defense makes the same argument. There's not one new argument that was made today that was not addressed in the original motion and the litigation that was 3 years ago.
All right, I think we've covered this sufficiently. Let's talk about the People's 1101B motion to admit evidence of a theft. And here, this I looked at People versus Clark, which came down Monday. That was the California Court of Appeal ruling. It was a nice description of ultimate facts. And
Your Honor, very briefly, before the
Yeah.
court goes there,
Yeah.
I mean, I just want to augment something that I did not put in the motion, but it's very important. I want to make sure the court's aware of this. The court has already admitted evidence during Tom Durst March 11th testimony. Mr. Durst, the following is an exchange that occurred on that date, on March 11th, 2020. This occurs starting at page 143, lines 25 through 26. I asked him, I want to go fast forward to December of 1981. Do you recall being in New York City? And I'm going to lead you here right now, so listen to my questions very carefully. Did Kathy make clear to you that she had information about impropriety involving her husband Bob and what he had been doing with respect to the Durst organization? I then at that point explained that that statement was not for the truth of the matter asserted. The court said that was correct, clearly not for the truth, ladies and gentlemen. Whether or not there's impropriety is not the point. This is not proof whatever. The answer, it is not proof of anything improper. There is a different purpose for which is the effect of the hearer. You had a question, and I said, well, it's going to motive. The main point is that it's not to prove, this is the court, whether or not there was something improper. I said motive would be the simple answer, Your Honor. The court then said it will be offered for a different purpose that will be explained later. And then he answers the question, that was asked before, and the question is, during your conversation with Kathy when she was upset, did she make clear to you that she was aware that Bob Durst, her husband, had been engaged in impropriety involving assets and money at the Durst organization? Yes, she did. So let me be clear, and this is a fault in the motion was done. I should have included this in the motion. I did not have the transcript handy when I had it. I should have cited to it. But here's where we're at, and I want to make sure I'm clear on this. The evidence is already coming in, not for the truth of the matter asserted. So Douglas Durst has the same information that Tom Durst has. But in addition, Tom Durst was simply testifying to what Kathy told him. So whether or not Bob Durst was stealing from the Durst organization, Tom wouldn't have had any information. Douglas Durst also, and this is discovery that was turned over to the defense 5 years ago, this is in all of the interviews with Mr. Durst, Douglas Durst, on 3 different occasions, as said in the motion, in essence, caught Bob Durst stealing. And I just want to be clear that although it is certainly relevant whether or not the allegation of stealing is true, so whether, let's back up, whether it's true or not, it's still relevant. So as an example, if somebody is saying that I'm a child molester.
I understood your argument, it's in your brief.
So what I would just add, Your Honor, is that when you look at it, obviously, if a statement is false, if somebody is being accused of being a child molester and they are actually a child molester, they have a much stronger motive. And I would simply add that when you look at 352, the idea that this jury is somehow going to convict Mr. Durst for the crime charged in this case because almost 40 years ago he was stealing some money from his family's organization is laughable. There is no prejudice whatsoever. If it were the other way, if we were using the murder as 1101B evidence to support a theft charge, they would have an argument. So the first point is that we've already, the only issue that we're bringing up right now is, can Douglas Durst testify to the actual incidents in addition to Kathy coming to him and telling him Bob is stealing?
All right, so the tentative would be no. The tentative would be to deny the people's motion, and this is why, is that it's remote. The accusation matters, all right, and that is important, and that is admissible. It's evidence of motive, which is an intermediate fact, which leads to another intermediate fact that the defendant had a motive to kill her, which is a fact which tends to prove the defendant did kill her, which is an intermediate fact leading to his belief he'd be prosecuted. I think it's intermediate. It's arguable. We don't have time to get into whether or not it's actually an element that he committed a crime. I don't think that people should have to. This makes it less probative, and though it isn't in and of itself compared to everything else, of course the jury's not going to convict him because of that, but I don't think that's the true test. I think the real test is weighing the prejudice of yet another wrongdoing pointed levied at Mr. Durst versus something that doesn't really prove very much that he actually is good for the theft he's accused of.
Your Honor, just addressing the remoteness issue, I think what's important is you have to look at remoteness not in terms of the trial. It's remoteness in terms of when he was stealing.
No, the remoteness in terms of its probative value. In other words, it's not remote in time, but in the chain of proof between intermediate fact and another intermediate fact and then another intermediate fact and then ultimate fact. It is so removed from the fact that jurors are to be considering that it's, first of all, an
able to testify that about Kathy making the statements to him about what Bob had done. I will not be able to supplement that with him be asking the court to take remote testimony from all out-of-state witnesses over X age. I think what we'll be requesting with the court at this point in time is if we have a witness who can provide specific information as to why they will not be able to come to court, then that is somebody that we will then ask the court if we can handle remotely.
So why don't you withdraw the motion and refer to this by reference? I do think that you've definitively shown statutory authority, constitutionality, and what's missing is the showing of necessity. And given, and if things aren't good enough, presumably they improve, hopefully they
Right.
improve, otherwise it's moot. So, but as it improves, if you still, for some reason, because of specifics regarding this witness can't do it, I'll hear you.
Right,
So
and
thank-
by this witness meaning any witness that,
Yes.
there was nothing, the specifics of this witness were simply the timing, and she was a physician, et cetera. So if we have that problem, Your Honor, going forward,
Yes.
we will address the court, but we understand it's important that Mr. Durst be able to confront and cross-examine the witnesses to have them here, and we're gonna try to get everything here. That being said, we are still in the process right now. There are 3 witnesses that we did conditional examinations on that that we don't have stipulations at this point in time. Nick Chavin, Linda Obst, and Ricky Ring. I've told the defense that as far as all 3 of these witnesses, I haven't been in contact with Ms. Ring, but all 3 of these witnesses are going to be coming to court. If the defense wants to stipulate to the testimony, I've told them we are willing to edit and bring it in. But in the end, they've got to tell us quickly because there just isn't a lot of time. And the interest in our part in doing this is that obviously people still have concerns about coming to court, flying across the country, et cetera. And in addition, they were thoroughly questioned during their conditional examinations. And so the people are willing to give up the fact that these witnesses would be personally in court if there's a stipulation like the rest. What we want to avoid, and what has been unfortunately the pattern, is that, as the court's aware, all of a sudden it'll be the day before and we've been offering something for 3 years and the defense says, yeah, we want to take advantage of that. And we can't do it. The logistics are just too difficult. So I wanted to make sure that I put that on the record. In addition, Your Honor, and I don't know if this was on the record, the court had previously stated in our last hearing over the phone, and I don't think we were on the record, or maybe we were and I just don't know it. On these calls, Your Honor, have we been?
No, those are informal, they're
Okay.
just like bench conferences.
And so, the first thing is, I want to make sure before we go that we end up getting a time waiver from Mr. Durst, because I don't know that we've officially gotten one. That's the first thing. The next issue is that the court had said that our physical exhibits for our mini opening statements, which the court has limited to 1 to 2 hours, are due from both sides by May 10th. That was not put on the record, but that is what the court instructed.
Right.
And I wanted to make sure that was down. The court had said we're allowed 1 to 2 hours. The court had said that we were okay, we're gonna be videotaping the witnesses who are testifying. We'll have a video,
Let's talk about that. We've got one room for 1 camera in the courtroom. What are you talking about? Are you talking about a second recording?
well, if we're gonna have access, in other words, if the court can order, I think they can, if the court can say, listen, the camera has to provide the footage to both sides, and they have to provide it in as real time as they can. In other words, at the end of the day or the next day, they need to provide us, then we don't need the camera.
All right, thank you. I'll look into that with our media office.
And then the Doug Oliver's body attachment, which was held until January 13th, extended to March 17th. The court informally extended that to May 17th.
Formally.
He did it for-
Oh, I didn't think that was on the record.
It was.
Oh, that was on the record, okay. Then those were the issues that we had, Your Honor.
One last housekeeping item is Dr. Charles Harvey from Galveston was the coroner. We have a stipulation to read his former testimony. I provided, it's not going to be a conditional exam video, it's obviously just a reading situation. I provided the defense with the transcript we intend to read.
Thank you.
And finally, we've also provided the defense with the transcript of Mr. Durst's testimony. I believe we haven't, maybe we haven't. If we haven't, we are going to be utilizing Mr. Durst's Galveston testimony as pursuant, as a hearsay admission. So that will be read in, and I had a question for the court. How does the court want to handle? We have a number of witnesses from Galveston where both sides have stipulated to testimony to be admitted. In addition, although the defense, they didn't have to stipulate, we're going to be having Mr. Durst's testimony read in. how does the court want to do that logistically? Does the court want to have, so for instance, is one of us to play the part of the prosecutor? Is the defense attorney to play the part of the defense attorney, and then we furnish a witness? How does the court want that done? Because I have to start recruiting people to be reading this stuff.
Some of them are long.
Some are long.
The
Absolutely.
court has a speaking part as well.
Yeah, when I was a lawyer, I was a reader. When I walked in to watch my friend try a murder case, and Judge pointed, brought me up, and I'm reading this testimony of the alibi witness who was in the barracks with the defendant at the time of the killing, and I'm testifying to everything I remember. And I went and sat down to watch, and this reporter swoops over next to me and says, "So you were in the service?" I guess I
You've done a great job.
Missed my call.
Your Honor, given that, if you would like to audition for any of the roles that we have out there, we would
Right.
give you serious consideration.
It's up to you. I've seen all of it.
Okay.
You work it out.
Will do. Thank
Anything
you.
else? Anything else?
Your Honor, Chip, are you going to address the juror question?
Yes, sir.
Thank you.
Just a moment. One more thing.
I expect to be disturbed.
So when we return, it'll be May 17th, 8:30 a.m. And let's see, I think this is it. Anything else?
Briefly, Your Honor.
Yes.
We had, amongst ourselves in the various pretrial conferences, the phone calls, and Zoom things that the court has been so kind to coordinate in the run-up to trial, we had discussed the idea of a very brief questionnaire for the jurors that you are asking to return or directing to return on May 17th. Originally, the people were also in favor of that in some form or fashion.
We actually have never been in favor.
Okay, I will make inquiries, but it will not be by way of questionnaire.
Can we, would it be okay, Your Honor, if we submit proposed ideas for you in that inquiry?
You may, but I am going to be mindful of jurors' privacy, so certainly they are going to let me know if they are not, if there is an issue with interfering with their ability to serve, but I have an obligation to safeguard their privacy. Town cell versus Superior Court, 20 Cal 4th, 1084 at 1094. Okay?
Your Honor, on the 17th, are we supposed to be prepared to give opening that day?
Yes.
Or is it, okay.
Well, you know something? Really, practically, I expect we'll have some dialogue with jurors.
So can we say the 18th then for opening statements, Your Honor?
That's, we will knock on wood and hope for that. We'll take the time we need to explore with the jurors any issues they may have, so maybe the 18th and maybe the 19th. Certainly no later than the 19th.
No, but not the 17th, that was all.
I can't see it happening on the 17th, and I don't expect you to do it on the 17th.
And Your Honor, as we sit, is there any further change on no further information on the number of jurors? As far as we know, we're in the same
Correct.
position as you
Yes,
said.
no, we've been nothing from jurors.
Thank you, Your Honor. And that's 9 o'clock on the 17th, correct?
8:30.
Oh,
I'd like to
8:30.
be at 8:30, but we'll commence at the jurors at 9. We're doing our best for 8:30.
Thank you, Your Honor.
We have technical problems today. All right, is that it? Anything on the phone?
What will the, in this courtroom, what will the hours be for the trial?
9 to 4:30. 4:15.
One more thing, Your Honor.
Yes.
For the court reporter, we'd like to order today's transcript and the sealed portion, please.
Hey, we'll communicate that to her.
Thank you.
Anything else?
Well, thank you, Your Honor.
All right.
Yes.